Going to start now. Today is the 251st Friday group meeting. Topic is Statutory Interpretation Simplified, a common sense approach to difficult subject. The speaker is Mr. Ramakrishnan Viraraghavan, Barrister and Senior Advocate. Last time also he addressed our Friday group, that is 192nd Friday group meeting. This is dated 13th October 2023. Constitution of India and principles of interpretation that time. Sir, now you can address 45 minutes your speech. If any question answer, vote of thanks and another thing. Please, sir.
Should I speak? Is it coming okay?
Little loud.
Thank you, sir. And it's a pleasure, as always, to address this very interested and erudite audience. Now, this is a subject which G.Seshagiri and I were discussing. Now, in my younger days at the bar, this was one of the most difficult subjects I could think of. I couldn't make sense of it, and I didn't know if I'd ever understand anything about it. I just wanted to read enough to pass the exams and come out. But after I started practicing, I found, to my misfortune, that almost everything we did in the High Court involved statutory interpretation. Everything. Interpretation of statutes, interpretation of contracts. There was no running away from it. And then the added problem was English and statutory interpretation itself was difficult. Then in English you added Latin maxims. I mean, how can you understand? English is a foreign language, and then you add another foreign language and connect both. How do you pronounce Latin words? It was a complete difficult subject, and somehow I was wondering how to get out of it. But two things happened. When I qualified as a barrister and I was practicing in England, I found that most Englishmen hated Latin maxims. And there was this Lord Chief Justice of England at that time, Lord Wolfe. He made it a point that judges should not write Latin maxims in their judgments. He said an Englishman cannot understand Latin maxims, and you must write judgments so that a common man can understand judgments. Then the next step was when I wrote this book on GST. I couldn't avoid statutory interpretation because one of the chapters in every textbook is on statutory interpretation, and it's a complex law, GST legislation. So today my objective is, I would like to hand across a book on Bare Act of GST and IGST to the audience here, and let's have a discussion on how to interpret something which is arguably the most complex legislation in Indian tax. And my objective of today's speech is, after this discussion, you should be able to go home, take up any Bare Act and interpret it on your own, without any Latin maxims, without authorities. Interpret it and find your ideas of interpretation by yourself. And after you do that, then you can search authorities to support or oppose your proposition. That's the objective. And so the first question is, what is interpretation? I would like to start with translation. Now, you have seen TV news where sometimes you have an interpreter for the hearing impaired. So whatever is spoken in voice, it is translated in signs for the hearing impaired. Then you have subtitles in foreign language movies. You have the subtitle running at the bottom. That is a translation of what is in English or other language into a language that we know. This is translation, one language to another. Interpretation is explaining the same language. That is interpretation. Translation is one language to another. Now, why do we need any of these, why do we need interpretation at all? I'm moving from law to evolution of human beings and human anthropology. Yuval Noah Harari, he's a leading author and a famous history professor in Israel. Now, he was debating on why human beings came to dominate the world as a species, all of us as a species. Now, you have animals with more intelligence and bigger brains. Elephants, whales, and dolphins are also supposed to be a little more intelligent than us. The question is, why aren't these species able to dominate the world? They are stronger, they have bigger brains. We are such weak beings and we have small brains. Why do we? And his theory is the secret is communication. Now, if you take a troop of elephants, maximum limit of communication is about 100, 200. Beyond 200 elephants, they cannot communicate with each other. But take human beings, we can go to any court in the world or maybe in India and start speaking, you will have people to communicate with. When I was practicing there, I think Lord Judge, now he's no more, he was the Chief Justice of England and Wales. And he was telling me he went on a trip to Calcutta and the Chief Justice of Calcutta said, why don't you sit with me? And as a courtesy, he sat on the first bench with the Chief Justice. He said, if I close my eyes, I will be in my own court. Because the language, the procedure, everything was so similar. The secret of human being success is then communication, ability to communicate. And when you talk of communication, it is important that the speaker is clear in what he says and the listener is able to listen without confusion. And this is very important in human beings and in law. Now, human beings, what is another interesting thing is, if you look at the eyes of animals and the eyes of human beings, we have the whites of the eye. If you take an eye, the black is small and the whites are very big. Animals don't have them. And the theory behind this is, human beings can communicate by moving their eyes. From a distance you can see what they are trying to say. Very often in court we communicate with our eyes. We don't want the judge to see, we want the other side to see. So that is why communication is important. Then we go on to communication and law. Most of the important concepts in law are illusions. Why do I say illusion is, take company. Corporate law is the money spinner here. What is a company? Company is an illusion. Then take our constitution. What is in a republic? India is a union of states. How do you find out what a state is? How do you find what a union is? Kingdom is okay. Kingdom, you can say, a kingdom is the territory which a king can control. So you know it is physically that he can't control. I think there's this very nice thing about Shah Alam. Sultanati Shahi Alam as Dillita Palam. So Shah Alam Sultan went from Delhi to Palam, that is all he could control, but his name was ruler of the world. It is an illusion. Then NCD, what are the boundaries? Everything is an illusion. And how do you bring this illusion into life? You bring them through statutes, you bring them through words. And that is why interpretation is important. When you have words, what are words and statutes? They are communication by one central agency to the rest of the country. In fact, Winston Churchill said India is not a country. India is a geography. It is like the equator. How can it be a country? 75 years we have proved him wrong. We are a country, and we are a country because we are united by laws. We are united by constitution. We are united by all these state laws. So this legal framework is what gives us the substance to go forward as a nation. So we come back to communication. This is communication in writing, and when there's something you communicate in writing, you go back to Sir James Fitzgerald James. He was the sole person behind the Indian Evidence Act, now no more, but the predecessor Evidence Act. And he said something important. He was, I think, a member of my inner temple, and then he didn't have much of a practice as a barrister. Then he was appointed here on the Viceroy's Council, and then he started shining. He drafted the Evidence Act, then he was, I think, knighted, he went back to England, and he had a great reputation. And he was saying, when you draft an act, there are three principles actually. The first principle is, when you are drafting an act, it must be in a language that a common man can bona fide understand it. Then he said, after you cross that, second stage is, a mala fide man should not misunderstand it. So you must draft it that way. The third stage is, it should be so well drafted that even a criminal will not even attempt to misunderstand. It is settled. So these are the three stages of communication in a statute. And what is communicated in writing is slightly different from what we are communicating orally. When we are communicating orally, lot of things are communicated by, again, the eyes, by facial expression, gesture, tone, volume, context. But all this is not possible in a written communication. So how do we get over these difficulties? We take some of the principles that we use in a normal conversation and import them into the written statute. That's the theory of interpretation, a common sense approach, because nobody asks us how we converse. We get it automatically. And the same approach should be for statutory interpretation also. And when you start with statutory interpretation, the first thing is, the words don't matter much. The context matters. Now, every day we say things, in the court, every day we say things which we completely do not mean. Now, let's say you start an argument saying, with great respect to my learned friend. You're not respecting him. You're probably thinking he's not even learned, he's not my friend. But you start off by saying, with great respect to my learned friend. Nobody understands that you're respecting him suddenly. But you know the context, the words don't matter. Then you turn to the judge and say, your lordship well knows, with your vast experience at the bar and the bench, 100% you know. He doesn't know, I know he doesn't know, and you're saying these things to tell him something which is unpleasant. So the context matters. In statute also the words don't matter much, the context matters. It's all about, context is the king. And when you talk of a context, the context goes from inside to outside. How do I say this? When you take up an act, why don't we pass on the GST Act just as I'm talking? I have some GST, why don't you just pass it on to the audience? And some of these also you can pass on. I'll have one book for me and the others. What I'd like you to do is, I'd like you to read this along with me, and then let's look at how the GST is to be interpreted, and the same way we can use all other acts. So please take any section. I'm having with me section 12. I flagged the section, so you take the flag, it's section 12. I'm reading section 12, subsection 1. It says, the liability to pay tax on goods shall arise at the time of supply as determined in accordance with the provision of this section. You might want to take section 12 there. Okay? So let's say you are completely new to taxation. So you read this again. The liability to pay tax on goods shall rise at the time of supply as determined in accordance with this provision. So the context you need to say. Let's say you don't know what goods mean, you don't know what supply means. So you read the whole thing. You start with the word, then go to the subsection, then go to the entire section, Then go to the chapter. You have the chapter heading, Time and Value of Supply, at the beginning of the... This is at what, page number 155. And when you have the chapter heading, you go to the headings of various other chapters, which is beginning at the book. And then you have the context. So inner to outer is where you go to the context. Now, as in normal human conversation, the principle is intention is more important than the words. With great respect, then the intention is more important than the actual words. When we are talking, you are able to assess the intention of the person by what he's doing and what you are doing. Here, our objective, my intention is to convey something on interpretation of statutes, and you are listening there and you have doubts, your intention is to ask me questions. Intention is, in law, intention is always a question of fact. Intention to kill, intention to commit fraud, all these are intention. I think a judge famously said, a man's state of intention is as much a fact as the state of his digestion. Okay, let's import that into statutory interpretation. We all hear the words, interpretation of statutes is a means to find out the intention of the legislature. Okay, let us take the Evidence Act, which is recently repealed, or let's take the Contract Act. They're all acts of 1872 Indian Contract Act. How do you find the intention of the legislature in 1982? They're all dead and gone, 200 years gone. Okay, now let's take an intention of a very recent bill, parliamentary bill. Finance Act is now being debated. Finance Act 2024 is already there. You need to interpret Finance Act 2024. The parliamentarians are still there. This is the same parliament. Can you go and ask each of them what is your intention in this? Cannot be. In fact, yesterday was an interesting, 2 days ago, there was an interesting argument at the Supreme Court challenging a particular bill which became an act. On the ground there was no debate in the parliament. Then they produced the parliamentary debates. It said the bill was introduced, then uproar in parliament, walkout in parliament, bill passed. That is all, no debate. So the submission was, please declare this invalid because there is no application of mind, non-application of mind. Then the court pointed out that cannot be, because when you say intention of parliament is the intention of each of the parliamentarians, then you have to bring them and cross-examine them. Somebody can say, I voted it. And why did you vote? Because I wanted to rush out. And this senior member was looking at me, so I had to vote and run away. It is to avoid this that interpretation of statutes, we say intention of legislature, not as an issue of fact. We say intention of legislature as a shorthand to say what does the act mean. Instead of asking what is the meaning of the act every time, we use the words what is the intention of the legislature. So intention of the legislature is not a statement of fact. It is not a factual intent. It is a legal shorthand to find out what is the common sense meaning of the words. And because of this, it is wrong to rely on legislative debates to interpret a legislation. There might be some debates. You can show it to the courts and say, look, this has been debated, but that is not conclusive. If you look at one of the recent parliamentary debates on the constitutional amendment bill, I had written an article on this. Each of the members said something different. And how can you find out the common intention? So, first thing you must remember is, forget intention as an issue of fact. Don't get into the minds of the parliamentarians. Look at intention as what the legislature actually told us. This was different in the very ancient past. One of the first legislatures by the people was the Greek legislatures. Greek legislatures were city-states. Athens was a city, Sparta was a city, and all the citizens of that particular city used to assemble in an amphitheater and they used to debate. And whenever the legislature was in session, many of them ran away because they had other work to do. Why should they sit and debate? Then what happened is, these government officials used to carry a big rope with a blue colored dye or red colored dye, and they will surround people. So the only way to avoid their clothes getting dyed in this color is to go to the legislative assembly and sit there and debate. So each citizen participated in the debate, and if they had any doubt, they can always ask their neighbor, what did you debate? So their intention was an issue of fact. You can always communicate, find out what was the intention of the law and get back. But that is no longer possible, because here in these large countries, not city-states, throughout the world in democracies, we cannot ask the legislature, and the doctrine of separation of powers is an important concept to prevent power being unified in one single person. As Lord Acton said, power corrupts, absolute power corrupts absolutely. The separation of powers means executive, legislative and judiciary are kept separate. I want you to imagine a dialogue between three people, a conversation between three people. One is the speaker, the other is the worker, the third is the follower. Three people there. So the speaker says something, and then the worker understands and does that work, and that has an impact on the follower. So these are the three people. How do you understand what the speaker has said, whether this worker has understood it properly or is deliberately misinterpreting what the speaker has said? The worker must ask the speaker, or the follower must ask the speaker. This is the common sense approach. But here in the doctrine of separation of powers, the legislature can only speak. The worker can only implement, and the follower has to comply. The normal citizen has to comply. If either of the worker or the follower has any doubt on what the speaker has said, you cannot ask the speaker. The fourth person, namely the court or the interpreter, you have to ask him, what did the speaker say? And the interpreter will say, look, according to me, the speaker said X, Y, Z. The speaker can't open his mouth and say, no, I meant something else. The worker and the follower cannot say that. If they think that is wrong, they must address their arguments to the interpreter. And whatever the interpreter says is final. This is the separation of powers as it is in our legal system. What happens if the speaker disagrees with what the interpreter said? He cannot open his mouth, but he will issue another legislation saying, this is what I meant. And this legislation will go back again to the speaker, and the speaker will interpret it. Sometimes the speaker will deliberately misinterpret it. And my favorite example of this is Keshwananda Bharati. Keshwananda Bharati, the constitution was amended to say the constituent assembly, namely the parliament, is supreme. Every part of the constitution can be amended as it wills. Struck down. Went back again. The speaker, that is the legislator, once again said this. But the Supreme Court said, no, there is something called basic structure, and that cannot be written. So that is completely different. So when the interpreter says something, no matter what the speaker screams and shouts, the interpreter's word is final. And that is the supremacy of legislation. As I think one of them said, yes, it was Lord Coke or Lord Bacon. he said, you're all lions. He told the king, you may be a lion, but you're a lion under the throne. The constitution sits on the throne. This is the unwritten English constitution. Be ye ever so high, the law is above you. There's one exception probably. Justice Narsingh, he's sitting judge of the Orissa High Court. While we were debating this issue in the National Judicial Academy, he said an exception to the rule is the presidential reference. Under the presidential reference, the worker can directly ask, but the judiciary, this is what I interpret, what's your idea on that, what's your interpretation? But still, the parliament cannot ask the judiciary directly. So the starting position in the context, I think you must just take any statute. Any statute, the first time you get a complicated act like the GST Act, it is terrible to read it. I don't know why they have passed this, you can't understand this. So I think the first thing is you must start reading it like you would read a novel. Difficult though it is, don't try to figure out anything, just keep reading it. Second reading you might understand the plot. Some of these complex novels you need a second reading to understand the plot. This is something like that. So you read this and then you remember context is the king. So let's go back to section 12 and I'll tell you how it should be read. So you start with, let's say you are interpreting section 12(1) and the section says liability to pay tax on goods shall arise at the time of supply as determined. This is okay? As determined in accordance with the provisions of this section. You might have doubts on one or two things here. So let's say you have a doubt on goods. So what is the meaning of goods? You make a note of that. Then you probably need to know what is supply. The normal rule is words used in a statute are words used in common sense English meaning according to normal English grammar. Nothing unusual. So the intention of the legislature is expressed only by the words written by the legislature, not more, not less. And because of this, you take words with a common English meaning. So when he says goods, it doesn't mean cash, for instance. Cash is not normally goods. Or when you say supply, supply does not mean destruction. You're destroying something, you're not supplying something. So these are basic rules. Then the second basic rule is, when you're reading subsection 12(1), you don't delete words. When you're interpreting what somebody has said, you don't blank out words that he has spoken. Similarly, you don't blank out words we are written. Second thing is you don't add words. So in interpretation, first, normal English meaning, normal meaning of the words, don't add anything, don't delete anything, and then look at the meaning. If you still have doubts, look at the context, overall context. For example, subsection 1 talks of time of supply. Then the chapter heading talks of time and value of supply. Then subsection 2 says, the time of supply of goods shall be the earlier of the following dates, namely the date of issue of the invoice, the date on which the supplier received the payment. Let's stop here for a moment. They are saying time of supply of goods, but when you go to which is the earlier time, they are not talking of time. They are not talking of 9 in the morning or afternoon. They are talking of the date of supply. So now you know, in the context in which this section is said, time of supply does not mean the time by the watch. It means the date of supply. And then you go to the date. What is the date? According to our Hindu almanac, the day begins when the sun rises. It ends at sunset. The next day begins the next sunrise. But under English law, it is midnight. Why such an artificial time, midnight? I don't know. But here we go back to, where do you find what is the date? Then you go to three things. First you go to the definition here, then you go on to first definition. There will be a definition clause in every act. Then you go on to General Clauses Act. If it's a state law, many of these states have state general clauses. So whichever way it goes, you go to the general definition then. Now GST has a definition. Every act has a definition, almost every act. But again, when you go to the definition clause, you see a very important phrase which is like a mantra every time. It says, in this act, unless the context otherwise requires. So the definition given by the act is again overridden by the context. If there is a definition of a particular term and the context overrides it, then the context prevails. To give you an example, I've recently argued a matter on financial year. Section 10 of the CGST Act talks of the financial year immediately preceding the commencement of this act. Then you go to the definition of financial year. Financial year is the year beginning 1st of April, ending 31st March. Immediately preceding financial year will be the financial before that. The problem with GST was, it came into force in July, it came into force at the end of the first quarter. It came into force on 1st July 2017, what is the immediately preceding financial year? The High Court said the immediately preceding financial year was the financial year 1st April 2016, ending 31st March 2017. My submission was it is wrong, because there is always a presumption against retrospectivity. If a speaker is talking to you in a conversation, you assume he is talking about today, unless there is something in the context which says he is talking about yesterday or tomorrow. Similarly, when a legislature says something, it is talking of implementation from the time it made the legislature, not before. So if you say 2016-17 is the financial year, then you are giving retrospective effect to the GST legislation 1 year before even the constitutional amendment came in. Which means Parliament is assuming jurisdiction during a period when the Constitution did not give it jurisdiction. The only way to read it down is to say, look, we want to give sense to these words. You can't say there is no financial immediately preceding financial year for the first year. That is also absurd. So when legislature uses some words, you have to give an interpretation to the words. You can't strike off the words. So the court said fine. Then the interpretation suggested to the Supreme Court was financial year begins 1st April. So the immediately preceding financial year will be 1st April 2017 up to 31st June 2017. Those 4 months will be the financial year for the first year. Second year onwards, there is no problem. So far the court has agreed with me and they have stayed the operation of the order. But this is again an issue of interpretation overruling the definition because of the context rules. Then there's a very interesting thing of marginal note. I'd like you to take section 12 again in my book and take section 12 in the Bare Act. Do you have the Bare Act with you? Now, if you see the Bare Act, the section heading in the Bare Act is time of supply of goods. You won't find it there. You need to take this Bare Act there. Yeah, just take section 12 there. If you see section 12, it is written in bold and it says time of supply of goods in bold, and then you have subsection 1, the liability to pay tax. That is not the marginal note. Marginal note is a note given in the margin of every act. And the reason why no publisher publishes it that way is because this space, you see, this space is left blank. So nearly 15% more paper is consumed. Profit margin goes down by 15%. So no publisher ever publishes it that way. When you're in a hurry with your brief and some idea occurs to you, you make a note in pencil in the margin. That's the marginal note. This is also the marginal note. In the British Parliament, long years ago, the parliamentary draftsman, the clerk there, wrote the marginal note on the side, and that was to guide the MPs on what the section is about. So for a long time, the English courts refused to use marginal note for interpretation of a statute. The reasoning there is, marginal note was not enacted by Parliament, marginal note was not debated by Parliament, it was written by an official, and we will not consider it. Now, in the British Parliament, the marginal note concept has gone. They have started using the same thing as our law publishers are doing. They have had added section headings. In India, it is different. I'm just circulating, I think you can have a look at it and probably keep for yourself. This is the extract from the Finance Act 2024. Finance Act 2024 amended section 73, and see the amendment. The amendment says, in section 73 of the CGST Act, in the marginal heading, after the words determination of the tax, so and so period of financial year, etc., shall be inserted. So in Indian legislation, modern legislation, last 5 years, they have stopped calling it marginal note. They have started calling it marginal heading. I don't know whether it can be a marginal heading, but they are calling it that. And marginal heading is being debated in Parliament, it is being amended in Parliament. So in Indian context, marginal note is a very important measure for interpretation. It cannot control the body, the language, but it can guide the language. Then the next thing is on context as a whole. Context means the whole context, not a part of the context. So when you are interpreting a section or a subsection, you must make sure that your subsection, your interpretation of this subsection does not contradict the language of another subsection. So your interpretation should not lead to conflicts. The second thing is, one section should not be interpreted in a manner which conflicts with another section. As far as possible, try to harmonize the entirety of the Act. I'll give you another example in GST. Section 129. That section, I'll read it out. It says, notwithstanding anything contained in this Act, where a person transports any goods while they are in transit, and a lot of contradictions there. This particular section 129 is possibly the second biggest money spinner in GST legislation, because every transport truck from any corner of India to the other is stopped by using this section. And the smallest of things, smallest mistakes there are punished heavily. Lot of writ petitions are filed because the tribunal is not functioning, and in one of those writ petitions, the officer imposed a huge penalty. Small mistake in the goods, I think this driver wrote the vehicle number wrong, or probably the vehicle broke down and the new vehicle was there. And this officer said the value of the entire goods in the truck will be your penalty. Came up to the High Court. And in the High Court, there is another section, section 126. That section says general discipline for levy of penalty. And it says, no officer shall impose any penalty for minor breach of regulations procedural requirement, and in particular any omission or mistake in documentation which is easily rectifiable, made without fraudulent intent or gross negligence. So this provision was brought to the notice of the High Court to say, look, this is a driver, truck broke down, changed, omission, wrong number given, no fraudulent intent, no evasion of tax. But the department said section 129 starts with notwithstanding anything contained in this act. So we can ignore section 126, rely on this section alone. High Court said no. When you are interpreting notwithstanding anything contained in this act, it means if there is any conflict, that conflict will be overridden by section 129. But if there is no conflict, then you must follow all these sections. And the court said there is no conflict between 126 and 129 because 126 is general discipline. It makes sure your officers don't act contrary to Article 12. Do not act arbitrarily. So again, this is a reiteration of the basic rule of harmonization in the interpretation of every legislation. And then you have conflicts between one legislation and the other. Examples are CPC versus Arbitration Act. CPC has an appeal. Arbitration Act doesn't have an appeal. Then Arbitration Act against MSME Act. MSME Act has certain provisions for the MSME Facilitation Council, which is also an arbitration council. How do you handle these conflicts? Then you have another characteristic conflict mechanism which says this provisions of this act will override notwithstanding any other law for the time being enforced. Then you have three acts with the same mantra. Which overrides the other? Their common sense approach is when you're talking to somebody, he says something in contradiction to what he said before. You think whatever he said the latest will prevail. So similarly, this overriding clause opposed to an earlier legislation and a newer legislation, the new legislation will override the earlier. That's a basic common sense principle. Second, conflict between legislations, then you decide which is a general legislation. If your speaker is talking a general subject with you and he says something in contradiction over a particular incident which happened in his life, which is narrating to you, then you see, okay, what he's saying in particular overrides his general thing. So let's say generally he says children are very bad, and then he says no, this happened, my daughter did something very good. Then you can't question him. You're saying children are very bad, now you're saying this child is very good. General statement, and this is a particular instant, it overrides. Similarly, general acts are overridden by specialized acts. Then there's an interesting thing about interpretation of silence. In a conversation, very often, if somebody doesn't reply to what you have said or doesn't react, that itself is very important. In a SLP hearing, after hearing your vociferous argument, if the court doesn't say anything and just smiles, then you know what's going to happen. So, interpretation of silence is very important. If there is something before the court which the Act does not provide for, then it's an open field for persuading lawyers as well as the court to see whether it fits in or not. And some of the great judgments come because of that. If you ask the Constituent Assembly in 1950, what do you mean about privacy of the Indian citizen? They would have said, forget privacy, our priority is to feed the people. We are just recovering from a famine. Where is food for the people? And we have to safeguard our territory. We were suffering. I think the slogan then at the time of late Lal Bahadur Shastri was Jai Jawan, Jai Kisan. That was the priority. Privacy, nobody bothered about privacy. You don't even have shelter for the poor. Now we have privacy has become important because the basic requirements have somehow been satisfied, and the Supreme Court brought in privacy and Article 14. Unimaginable. Where is privacy in the Constitution? So what we do is, we read between the lines. And if you're much more senior, you start reading the white, you ignore the black letters, and you start interpreting the white outside. So that's the beauty of interpreting silence also. Getting? So Latin maxims, I've covered it already. Latin maxims are very rarely used in England. I've spoken to some of my friends are judges there. They don't use Latin maxims unless it is unavoidable. And some of the old school judges who have studied Latin in college, Greek and Latin in college, they try to use it to say that I know more than you, but generally not used. Then we come on to internal and external aid to legislation. That does not arise in a conversation. In a conversation, everything is one. But in legislative interpretation, you have some things in the statute, in the act. But to interpret this, you must know how it came in. And that is the legislative history. What is found in black and white in the statute is the internal aid to interpretation. What is outside is the external aid. External aid is twofold. One is historical events. Second is legislative history. Legislative history will be the bill, statement of objects and reasons in the bill, and the notes on clauses in the bill. This gives you the context in which the statute was introduced in the parliament. Again, it is about context. Everything is trying to find out the context. Then there may be commissions of enquiry or law commission reports which led to the bill. These are all external aids. Again, what is important to remember is parliamentary debates is not an external aid. But amendments moved in parliament and amendments which have been rejected, they are external aids. There was this famous ruling given by former Chief Justice D.Y.C. saying GST Council recommendations are not binding on Parliament or state legislature. It created a bit of a controversy in the press. But if you look at the legislative history of GST bill, the opposition every time moved a bill saying right there, be very clear whether the Parliament prevails or that prevails. And every time that bill was, the amendment was voted down, which means Parliament was always very clear that Parliament is superior. They can ignore the GST recommendation. You can't have, in India, you can't have a body other than the Supreme Court which is sitting on top of Parliament. So GST Council is not there. This is an external aid to interpretation. Then another aid is historical facts. This comes within what is called the mischief rule. What happened before and after. For instance, in the mischief rule, then let's take the Indian Independence Bill, which was 1947, which was moved in the UK Parliament. Interpretation of that bill, you need to take in the historical context of Indian independence movement completely. You can't have that bill without this. And that historical context, again, take your interpretation of the Constitution Amendment on Jammu and Kashmir. A lot of historical events were considered, both in arguments and thereafter. Privy Council case, historical events were considered. These historical events are factual events, but they are not given as evidence before the court in interpretation. Historical documents are considered. That document may sometimes be controversial, as in the Ram Mandir case. Some of them were controversial, but that was different because there was a suit and there was a trial and evidence was kept in. That was factual. This is legal interpretation. So I think this would more or less I think 350 where I'll stop. So this would, in summary, cover the gamut of legal interpretation. There are, of course, many technicalities and you can keep going on, but by and large, you read it and you understand it and then go to the judgments. Don't start with the judgments and the maxims and then come to interpreter legislation. You will never reach there. It's the other way around. Thank you. I will end with this. And any questions?
Thank you very much, sir. Very nicely you simplified interpretations. So many examples also you have given. We are highly grateful to you, sir. Rahul Sharma, please give vote of thanks, please.
Another enlightening lecture by Barrister and Senior Advocate Mr. Ramakrishnan Viraraghavan on the topic Statutory Interpretation Simplified, a common sense approach to a difficult subject. So you have given this lecture by referring to the GST Act and talked about the Latin maxims, and you told us that the context matters in statutes. The context is the king, and different myriad points like you explained, and the interpretation of silence and external aids, historical facts, the mischief rules. They're very enlightening, sir. And you talked about marginal notes, marginal headings, and in your previous lecture also you talked about the marginal notes in the interpretation of the Constitution, like how they are different, like how they are, people consider that they are articles, they are not articles, but they are marginal notes. They're very informative and enlightening. Thank you, Seshu sir, for organizing this wonderful lecture. It's a special day as it's your birthday also. Okay, yeah, thank you, sir.
Thank you, Rahul. Thank you, Rahul. Thank you very much.
Thank you.
Any questions, please, now? One or two questions, we'll go.